All right, so we're starting week 6, our emphasis on trial preparation. Trial preparation begins when you intake the case. The process obviously intensifies as the case preparation goes on. And then a special kind of preparation is necessary once you get a trial notice. And really before that, because, for instance, under the rules of civil procedure, you're only guaranteed 60 days notice under Rule 40 of the Alabama Rules of Civil Procedure. And there isn't a parallel rule in state court for criminal cases. In federal court for criminal cases, the Speedy Trial Act mandates that the U.S. Attorney must be willing to bring a case to trial, prepared to bring one to trial in 90 days after arrest. So there can be some fairly tight time frames. Now, there are all kinds of ways around that, and it's ultimately the defendant's speedy trial right, so the defendant can stop the clock, so to speak, in federal court. But in any event, sometimes, depending on how much and the nature of preparation that needs to be done, waiting around on a trial notice is not a good idea. But there will be a time when you understand that your case is likely to be set for trial, and what sorts of things need to be done when you're at that stage. And that's the sort of thing we'll be looking at. You build on the organization that has been going on since the beginning of a case when you're at that point of trial. For instance, that's a good reason to keep a regular habit of keeping trial files organized, putting things where they're supposed to be, putting discovery in the right places, keeping pleadings in order, motions in order, orders in order, that sort of thing, so that the file is not a jumble, and you don't have to go back to that point of organizing chaos. You would hope to be able to do more refined preparation when you're getting ready for trial. The first thing that I think you do is you become concerned about discovery, where discovery is in terms of its completeness, whether there are discovery that needs to be issued in order to get money back, or rather to get discovery back from the opposing party. Perhaps there are depositions to be taken in a hurry in civil cases. In criminal cases, it's a good time to get out the file and get with an investigator or the DA himself, or however that's done in your jurisdiction, and begin making sure that every item of evidence that you're supposed to have, that you have. If it's a capital case, or if it's a case where the DA practices open file discovery, then what the DA has, you're supposed to have, right? And that just takes indexing the discovery that you have and comparing that against what the district attorney has. Same practice in a civil case also. You just got to make an assessment of what you have, send that to the other side, and have them tell you if anything is missing from the discovery that you actually have. So once you're satisfied that you have the discovery you need, it's time to begin building the file folders, and whether that's paper or virtual or a mixture. Ultimately, it would have to be a mixture, because most courtrooms in Alabama are not equipped to be technology only, and it's kind of spotty. For instance, Lawrence County, which is a fairly small county, a rural county, has this sort of reliable and seamless technology, such that you've got an Elmo projector, you've got the ability to plug a computer into the system that will display video that's readily able for the jury to view. So in any event, whether you're doing a combination virtual or paper, you begin, at least the way I've always done it, is with witness files. And I want to actually, not before I get to that point, it's important to have a meeting to assign duties. You know, who's going to do what. If you've got one lawyer and multiple paralegals, or if you've got multiple lawyers and multiple paralegals, then that meeting needs to happen to make sure that people aren't duplicating effort, or that important things are not being left undone. But in any event, I digress. So going to the witness folders, what I think needs to happen in those folders is you have one for every witness that is likely to be important. And if they take the stand, they're important, unless they're perhaps, like in a criminal case, just simply the person who, for instance, transported the body from the scene of the killing to the Department of Forensic Science. That person may have to take the stand for purposes of the chain of custody, but ultimately they're not a critical witness. But anyway, if they're on the stand, they have the potential to be a critical witness. So make a file. Every statement they have made, whether it is a written statement, or in which case you'd put a copy in that file, or a video or audio statement, you would put a copy or a transcript or detailed notes about that audio or video statement. And then if there's a transcript of a prior testimony from a previous case, from a preliminary hearing, or something like that, or from a suppression motion hearing, for instance, that would go in that file, so that as the person's on the stand, if you need to cross-examine them with a prior statement, you have it there with you, not in a different place, but in that witness's folder. When you get up from the table to cross-examine that witness, or if it's your witness to do the direct examination, you take that folder with you. I also begin at that point, just when I know a trial is coming, to begin drafting my cross-examination, to know where all the places I want to go, and some headline questions for each of those chapters, if you will, in my cross-examination. And of course, you don't get tied down to your draft, but you have it there in that folder as well. Also, for direct examination of your own witnesses, those should be very carefully thought out. I would say scripted, but not rehearsed, if that makes sense. You always need to know what you need to ask. Your client needs to have some spontaneity, but the lawyer who's doing the direct examination always needs to know where he or she is going. So those witness files are very important. I think that a file for motions that will be pertinent as the case goes on, those need to be put in a binder or folder, and coupled with it should be a copy of the key cases that the motions may turn on. So that sort of thing should be done as trial gets closer. you would want a file for all of the attorney notes, because at some point I always like to go back to the first day I met a client, or all the scribblings that I've made, put those in front of me and go through them. Make a file for opening statement, for closing arguments, for notes and ideas as those events may come to fruition. Those are the primary things that I like to have in my trial box, or my folders, my notebook, whatever. Paper evidence and video or digital evidence, you want to certainly account for its presence, for its existence, that you actually have a copy of it, and how to get to it efficiently and quickly. And if maybe that paper is indispensable, since it might be the item you have to show the defendant. It might be the item you have to show the judge. It may be the item that you have to distribute to the jury to examine. A question becomes what might need to be enlarged or duplicated ahead of time for a demonstrative exhibit. If there's a piece of paper, a contract, a document that is key, it may help to make that a big exhibit, to have it enlarged and mounted on foam board. That should be done sparingly in a time when you can bring up an image on the technology, but using those foam board exhibits is a way to highlight the importance. Back when you might have 20 of those, a decade and a half or two ago, it's different. But if you just have one or maybe two now, it highlights the importance of that document, even though you could have pulled it up on the video. So with that sort of preparation of the file, and there's some specialized tasks that may remain, like, for instance, what to do when you get the jury venire. We'll talk about that next week. The jury venire is the list of people who've been summoned as jurors, and there's a particular way that I like to do research on those people, as a means of being able to begin with some sense of who they might be, but of course listening very carefully in the selection process, and being able to supplement what I found out already about them. Then there are some other tasks that involve perhaps exhibits, preparing special exhibits, perhaps enlarging or reproducing, that sort of thing, that would have to be done with consultation with the lawyer and seeing what the needs actually are. But there are the more mundane things that are equally important, beginning to deal with the client and their comfort or lack of comfort in the courtroom. And I've dealt with I've put some letters, some sample letters in the content this week of things that you might send to the jurors, or I'm sorry, to the client, to help them prepare and think about questions they might have for conduct of themselves in the courtroom. It sometimes is difficult to know what they don't know or what they are uncomfortable about. So that's a starting place. The other thing that is important, especially in in criminal cases is the client's family, especially if that client is incarcerated. If you've got a capital case and the family's very, very invested in it, it can be a complex thing to do all that outreach and so on. But it's something that has to be begun, and that's where the paralegal can be very helpful in dealing with those details. Some people may need directions to the courthouse, travel arrangements, sometimes important family members who would like to be present, need excuses for work, perhaps even some arrangements about accommodations, just all the things you will find out are a problem. You have to dig in sooner than later and find out, what kind of expenses you may be looking at, and especially if it's an appointed criminal case, which is in capital cases is a whole lot of what I do. I have to get court approval before incurring some certain expenses if I expect to get reimbursed. The other thing, if you've got a criminal case and a client is in custody, you've got to deal with clothing for them for the duration of a trial. Best to have at least 3 or 4, I hate to use the term outfits because it sounds like you're dressing children, but have enough clothes that you don't have to be anticipating that the jail is going to do laundry for them on a daily or every other day basis. And how that client dresses is entirely the preference of the client and the lawyer, but it's a interesting discussion to begin whether a person should have a tie on, whether that would make them so uncomfortable. But when you are talking about clothing, sometimes the lawyer has to advance the money for the clothing, or perhaps there's a family member who will do that, or a church family that will do that sort of thing. But I have gone to jails and taken people's measurements so that people can go shopping for clothing. Sometimes they're just those less than glamorous tasks where you have to measure somebody's inseam and their shoulders to fit with a jacket, because you don't want to trust the clothes closet at the jail. Either that they'd have something that would fit them, or they would have something that would be appropriate to court. I take all those intangibles very seriously. So then there's getting together just the ordinary supplies, pens, highlighters, Post-it notes, those sorts of things that are necessary at trial, a stapler, a good power cord to plug in whoever's devices may be necessary. Those kinds of things are the sort of details that can, if you don't, the sort of things if they're not a problem, then you almost don't notice them. But if you don't have the things you need in the courtroom, it becomes an issue. At some point, the technology run-throughs, go to the courtroom, see what's there. Do you have an Elmo projector? Do you have a video screen that needs a projector? Do you have a setup where you merely need an HDMI cord? And when you begin to use those, do you know what you're doing? I believe in those technology run-throughs so that you don't find yourself at the point of being at trial and having to rush around and finding out that you don't have something at the last minute. That is very important for somebody like me who came, and most of my education happened before PCs and laptops and all that thing. So those are the sorts of things that are important for preparing for trial, preparing the client, preparing the file, and making sure that you have the right supplies. Another thing that I would say is crucial is, as your trial date gets closer, locate and talk with your witnesses. Make sure they're where they were when you saw them last. People move. That's why it's so important to have their cell numbers. That's the least likely thing to change about them is their cell number. Their mailing address may change, but collecting good contact information ahead of time is the way to be able to do that efficiently. Let's say they have moved. Let's say they have changed phone numbers. Who is somebody they know that can get in touch with them? In other words, don't make the process of locating or relocating somebody complicated because you didn't have sort of redundant ways of getting in touch with them. When trial is getting closer, begin to speak to them about how you need to accommodate them for work. Do they need a ride to court? Do they need a subpoena? Whether they need it or not, should you have a subpoena for them? The answer is almost yes, because I've had situations where I thought a person would be at court out of their own concern and on their own will, but then it might be a penalty phase in a capital case where life or death is at stake, and a person gets a combination of worried and nervous or conflicted somehow or another, and they don't show up, or they may, I couldn't get off work, and don't expect them to be as principled and high-minded as you might think you would be in that situation. I've just wondered, what do you mean you can't get off work? It's your loved one's life or death. Sometimes people's minds work differently. So sometimes that subpoena is necessary to, one, get them there and to give you a remedy for the judge to stop the case, let you find the witness, or ultimately have them brought to court against their will, have them attached, that is, arrested for violating the subpoena. So keep those things in mind about locating witnesses, accommodating them, making sure they're still willing and on board, getting them subpoenaed, perhaps bringing them in to review testimony, to review prior statements, and to give them an expectation of what they might be, doing, needing to do, and to get ready for their day in court. All right, we'll talk about that in more detail, and other specific things for trial preparation next week when we do part 2. So if there are any questions about the assignments, let me know. I have posted the trial preparation article that Judy Clark wrote. I apologize for its quality. I tried my darndest to find it online. It's from the Champion magazine, the NACDL magazine, but even with my subscription, I couldn't find that article going back that far. And then the stuff about the client contact letter. Look at that and digest it. And when I say I wonder if there are ways to update that, certainly one shortcoming is those letters are probably both written by men. What concerns about dress in particular might a woman have that it's easy for me to tell a kid not to wear a ball cap or an untucked shirt or a t-shirt with a pot leaf on it, but the subtleties of what a woman might wear or shouldn't wear, that'd be interesting to put in that memo, or that letter that we would send out to clients. In particular, there's an instruction not to get bogged down in the actual witness preparation part, look at the document before you answer, or have both feet on the floor, look the guy in the eye. I'm really talking about more dress and demeanor for coming to the courthouse, the conduct of your client's family or friends who may be there, and that sort of thing. So that's the part of the letter I want you to concentrate on. All right, that's all. We will see you all next week. Have a happy and safe 4th of July. Bye.